Alrighty. So welcome everyone to this event, Sentencing at the County Court, which is part of the virtual VCE Legal Studies Week, which began today. My name is Ed. I work in the media team at the County Court and I'll be moderating this event. First, like to begin by acknowledging the traditional owners of the land on which we're speaking, and I pay my respects to their elders, past, present, and emerging leaders. All of the attendees of this event have got their cameras and microphones turned off, but if you have any questions or comments during the session, you can actually type them into the Q&A box, and you should see that at the top of your screen. If you type in a question, I'll get the question and should be able to put it to one of our judges. So the judges that we've got to speak to you today are the Chief Judge Peter Kidd, Judge Liz Gaynor, and Judge Mark Gamble. I'm just going to read a little bit about each of these three judges and then we'll get started. So Chief Judge Peter Kidd was appointed as the Chief Judge of the County Court on 28th of September 2015. Before he became the Chief Judge, His Honour had 20 years of experience as a criminal lawyer in Australia and overseas. His Honour was previously a Senior Crown Prosecutor, an International Prosecutor at the War Crimes Chamber of the State Court of Bosnia, and a Solicitor for the Commonwealth Director of Public Prosecutions. His Honour was also a member of the Sentencing Advisory Council. The Chief Judge holds a dual commission as a Justice of the Supreme Court of Victoria and sits on the Court of Appeal from time to time. Chief Judge Kidd holds a Master of Laws from the University of Geneva, where he specialised in international humanitarian and criminal law, and a Bachelor of Law from the University of Adelaide. Welcome, Chief. Judge Liz Gaynor was appointed to the County Court on the 13th of August 2002. Her Honour graduated with a Bachelor of Law, Bachelor of Arts from Melbourne University in 1979. After a short stint as a suburban solicitor, Judge Gaynor worked as a journalist with the Australian Associated Press for a few years before becoming a duty solicitor with Legal Aid Commission of Victoria. Her Honour signed the Victorian Bar Roll in 1985 and was a barrister until her appointment as a judge in 2002, where she primarily sits in criminal trials and pleas. Her Honour was also a committee member of the Criminal Bar Association in the 1990s, an assistant convener of the Women's Barristers Association in the early 2000s, and has served on the Forensic Leave Panel since the early 2000s as well. Welcome, Judge Gaynor. Judge Gamble. His Honour was admitted to practice in November 1985, and after spending 4 years as a solicitor in the Criminal Division of the Legal Aid Commission, now Victoria Legal Aid, His Honour came to the bar in 1991. Over the next 12 years, His Honour's practice at the bar included a mix of defence and prosecution work. His Honour was then appointed as a Crown Prosecutor in 2003 and a Senior Crown Prosecutor in 2007, took silk in 2006. As a junior barrister, His Honour appeared in complex cases without a leader, and as Senior Counsel appeared in the Court of Appeal in many important cases, some of which produced landmark decisions, including the Verdens case, which deals with the relevance and significance of an offender's mental impairment in sentencing. His Honour was sworn in as a County Court Judge in February 2009 and became the head of the Criminal Division of the County Court in 2018. Welcome, Judge Gamble. So we have been absolutely inundated with questions for judges, and we're going to move on to them very soon. But as I said before, feel free to type questions live and we'll do our best to get to them. So I'm going to put questions out to the panel and I'll leave it up to the three judges to decide who wants to answer each question. And I thought a good place to start would be this question here from Zach. And the first question is, what are some of the special considerations given to young offenders in sentencing? Over to the panel.
Well, perhaps I'll just kick it off with that one. Well, young people, the law says that for young people, we need to place a great deal of importance on their rehabilitation. The law recognises that there's a great community interest in having young people return to society as quickly as possible as productive and constructive members of society. If they're young, 18, 19, 20, they've got a long life ahead of them. So it's in everybody's interests that they become a law-abiding citizen as soon as possible. So that's one of the, and perhaps the principal consideration that has to be given to a young person. And perhaps one other one is that the law recognises that with young people, they are often not as mature, in fact, almost always not as mature people. So that reflects on our consideration of their moral culpability. They're still culpable. That's why they've been dealt with by the criminal law. They still need to be punished in some way. But if you compare an 18-year-old first-time offender to a mature 35-year-old with prior convictions, you can readily see that the 18-year-old is someone that is not as morally culpable as the mature 35-year-old with a prior history. So there are a couple of the considerations.
Thanks for that answer, Chief. I might direct the next question to Judge Gamble, considering the mention of Verdens in the bio. Someone's put through a question from Mount Erin College asking how the principles of Verdens apply in sentencing and how important are they to the judge when handing down the sentence?
Well, the principles in Verdens can apply in one or more ways in sentencing an offender, and it will largely depend on the nature and gravity of the particular mental impairment that is under consideration, and to some extent on whether or not that mental impairment played any part in the offender's commission of the actual offence. So it could, for example, inform the offender's moral culpability or responsibility for the offence. If an offender, because of the condition that they were suffering from, could not fully weigh the gravity of their conduct and the consequences of that conduct, then that's a relevant consideration. It may also be relevant to the type of penalty that is appropriate. For example, if an offender suffers from post-traumatic stress disorder, then that condition is likely to make the service of any custodial sentence more onerous than what it otherwise would be. Another example of that would be if an offender was on the autism spectrum. It may well be that their ability to gauge and interpret other people's behaviour and signals is compromised. And I hope you can well imagine how that could well impact and make very difficult such an offender's service of a term of imprisonment because that's a highly charged and volatile environment. And if they're not reading the signals of other prisoners, then they are very much at risk themselves. So they're just some examples of how that can come into play.
Thank you, Judge, for that thoughtful answer. Following on in the sort of mitigation realm, John has put forward a question about a person's upbringing as a child and how much the judge takes that into consideration. And there's a second part to the question, which is there an age or is there an age range where your upbringing may be less relevant to the sentencing judge? And if so, what is that age or age range?
Okay, well, I haven't said anything, so if that's all right, I'll take this one. Background's very, very important because when you're doing a sentence, you have to work out as well what are the prospects of rehabilitation, and often a person's past plays very heavily into their future. So quite often in courts, we see people who are offenders, but they've been virtually victims of crime since the day they were born. They've been abused by parents and step-parents, and they might have been introduced to drugs by their parents. They might have had a really dreadful history. They might have been abused by strangers. They might have had all sorts of traumas. So those sorts of things are very much what you take into account in terms of that person's background, and particularly that's so when people are younger. And in the children's court, for example, there's an enormous emphasis, nearly all the emphasis is on rehabilitation and trying to address, some of the problems that a person might have had. The other way that you look at a person's upbringing is whether they've got what's called a positive support. So they come out of, if they're going to come out of court, that they've got good family around them, that they've got a good structure around them. It can be a real problem when you've got somebody who's had a horrendous history. But the problem is that in the community themselves, they haven't got an awful lot of structure. So you sort of take that into account too, what sort of services that you have to build in. Age stops being much of a help when you get a bit too old and you've done it a bit too often. So you might have someone with a pretty bad background and, you know, everyone wants to jump in and help that person to overcome the sorts of difficulties they've had through no fault of their own as a kid or as a young adult. And, you know, but particularly if you've got someone who's like, you know, 38 and they've got a whole stack of prior convictions and they just keep doing it. You can see from the record how much assistance they've been given, how much help that's been given. And after a while, it gets to the point where you have more and more, there's a principle called protection of the community, that no matter what assistance this person gets, they keep offending. And so that's a danger to the community. So it's not so much what age does it cut out, it's more about what their prior history has been like and how long that's gone on. Having said that, the younger you are, the more rehabilitation is going to play a big part. And when you're looking at rehabilitation, you have to look at background as well. And there's a very big change in how the courts look at things once you leave the children's court and you come into the adults court when you're 17 or 18.
Thanks for that answer, Judge. That actually did take us somewhat to the next question that I wanted to put to the panel, which was, do judges find it personally difficult to balance rehabilitation and punishment? And is there any insights you could share in how you work that balance out when you're deciding reasons?
Yeah.
Judge Gaynor, I think you'd be good at answering this one.
I have lots of trouble balancing rehabilitation and punishment, you know, particularly when you've got particularly when someone's just had a horrendous background. And a lot of the time you just sit there and you think, oh, you know, if I'd been born into that family, that could be me. And, you know, people develop shocking psychological problems. Inevitably, there's it ends up to a dependence on ICE. You know, and then when people use ICE, they just have this terrible cycle and we have so much offending is based on ICE now. You have this terrible cycling where the more they use, the more they need, the come downs are worse, the more drugs they need, and then they start offending. And then you can see very often why people have started using ICE because there's a term that psychologists often use. We get a lot of psychological reports where they talk about this person has been using drugs to self-medicate. But then they go on and on and on, and then you have to think it's not just punishment that you look at. You look at protection, like I said before, protection of the community. What's this going to mean for this community unless this person is actually stopped? So it's a really, really difficult exercise somewhere, particularly when you're feeling very, very sorry for the person. You then have to balance that up with, oh, but you know, this has been going on forever. Sometimes, particularly with heavy ICE users, they go on this spree of offending because they're just using so much ICE, so they've got to get money for it, so they're using. And sometimes they just need to go and bang up to a brick wall. And jail is often that. It's often the only, you know, because they're confined, they can't move, they'll detox. So I sort of comfort myself with that. But yeah, it's a really difficult exercise. Sometimes the offending itself, the particular offences that you have where somebody has been in a dreadful car accident, culpable driving, which involves usually a combination of negligence and drugs and speed, and someone has died. That person then has to go in, and you often have cases where you're not talking about will they go to jail, but how long will they go for? So it's quite a complicated sort of exercise. In that sort of case, again, you look at their background, whether they've got prior criminal history, a bad prior history, those sorts of things. So you always take those into account. But in that sort of case, then you're just looking at, well, how long is it going to be for, not whether they go to jail. But often judges agonise over whether or not to send someone to jail. We get a lot of material, we get a lot of psych reports. We'll have families sitting there crying in court, you know. On the other hand, you'll have victims of crime sitting in court, and often they're sitting in court crying over what's been done to them. So you've got all these factors to take into account. So it's always a difficult exercise.
Ed, can I just add something in relation to that question?
Please go ahead.
punishment and rehabilitation and even protection in the community are not necessarily mutually exclusive.
That's right.
They can be all addressed by the one sentencing option. For example, with a young first-time offender who has committed a serious offence, but for which it's important to avoid a custodial sentence, a community correction order for a lengthy period with supervision and treatment conditions for psychological counselling, drug and alcohol treatment, and testing and other conditions can appropriately balance and weigh all of those sentencing principles. To turn around a first-time young offender, as the Chief Judge said, away from a life of crime can address the community's concern about recidivism and the like. So they're not always pointing in different directions.
That's right. And with the community corrections order, you can try, and they have to do a lot of work hours. And the other thing, which I often think is the biggest punishment of all, is you can make them come back for judicial monitoring. So they have to come back in front of the judge. As you know, sometimes if I've got someone who I think is really wobbly, I'll say, I want to see you in 6 weeks. And the corrections person will turn up with the person I've just put on a community corrections order with a report, and they'll say, we're not over yet. You haven't seen the last of me. I'm going to see you in 6 weeks and I want a good report. Okay. And so they know, and that sometimes helps as well. So what Judge Gamble said is entirely right. I sort of took punishment as meaning jail, and that decision about going to jail is often a very hard one.
Thank you both. That was a really thoughtful answer.
Can I just add something to that, Ed?
Go ahead, Chief.
The law is also not mathematical. Some people think that it is. And it applies, whilst the same law applies to everyone, the outcome is tailored to the particular circumstances of the offence and the offender. So let's stick to the theme of a young person. A young person who commits a crime of moderate seriousness, but who's shown very good prospects of rehabilitation. Let's say they've had a drug problem, but they've demonstrated through treatment that they're able to kick that drug problem, which bodes well for their future, especially if the crime was drug related. So then the court may place a great deal of weight on the prospects of rehabilitation, more so than punishment. But if that young person has committed a shocking crime, for example, a shocking sexual crime of violence, then less weight will be placed upon the rehabilitation and more weight will be placed upon punishment. Ultimately, judges are required to impose a sentence which is just and appropriate in all the circumstances for that case. And the law is flexible enough to appropriately take into account all of these factors, which sometimes pull in different directions.
Yep. Exactly.
Thank you, Chief.
Yeah.
I might put the next question to you as well, Chief, because I've heard you speak about this particular point before. We've had a number of questions about the role of the victim. So we've talked a lot about the offenders, but what role does the victim have to play in sentencing, and how much weight does something like a victim impact statement have with the judge?
Yeah, well, I'll start off with that answer, but I'm sure Judges Gaynor and Gamble will have something to say about this too, because of the important role of victims in the sentencing process. Perhaps I'll deal with the broader question of the law. And this has been a really significant development in our careers. It wasn't that long ago where the victim didn't play any direct role in the process at all. Certainly when I started out in my career in the early 1990s, they played a peripheral role. One of the best developments in the law has been the involvement of the victim in the process. By law, the sentencing judge must take into account the impact of the offending of the victim. And also by law, a victim has a right to provide a victim impact statement. And the victim actually has a right to deliver that victim impact statement in a manner where he or she is comfortable. Now, sometimes victims will provide that in writing to the court and to the judge. And other times they'll actually stand up in court and read it, or have someone read it on their behalf. And as a matter of law, the judge must give weight to that impact. So if the impact on the victim has been much greater, then that's obviously going to have a greater impact. That's the law. Judges Gamble or Gaynor, perhaps I'll it'd be good to hear about your experience at the coalface there dealing with victims.
Perhaps I can just start off. It's significant that Parliament has seen fit to include the impact of an offence on a victim as one of the listed criteria in Section 5, subsection 2 of the Sentencing Act, as being one of the factors that a sentencing judge must take into account when imposing sentence. So that is a relatively recent development, as the Chief Judge has said, and it perhaps gives some illustration to how important it is perceived. That said, it is one of a number of relevant factors and it can't be overemphasised, but it is an important factor. It is also given a fairly wide definition in the Sentencing Act. A victim can be anyone who is impacted by the commission of the offence directly. To give that some context, in the case of a serious assault in a public place, which may be witnessed by a number of people, the witnesses themselves, who may have been traumatised by witnessing that assault to varying levels, right up to a post-traumatic stress disorder, they qualify as a victim and are entitled to inform the court about what the effect has been on them, just as is the primary victim of the assault itself. Liz?
They're also very useful. I can't sort of add to anything that the Chief Judge and Judge Gamble have said, but they're also very useful when you're dealing with an accused as well. And sometimes an accused doesn't quite get how serious what they've done actually is in terms of it impacting somebody else. And so what can happen with victim impact statements is that they either just get handed up and nobody reads them, or the victim will come to court and will stand up and read his or her victim impact statement, or or say they would like the prosecutor to read it out. And I often like to, during a case, I will often speak to an accused person and say, see what you did, see the effect that you had on this person. So, for example, you've got somebody, I mean, I keep using drug users as an example, but they're quite a good example because we have such a lot of them. But say you've got somebody who's gone into a service station late at night where there's just one person there, and they pulled out a knife or an imitation gun or even a gun and said, hand it over. And then you'll get a victim impact statement saying, I'm absolutely traumatised. I had to give up my job. I don't feel safe in the community. I can hardly go out. I've had to stop studying, those sorts of things. And it's really good to talk to an accused person and say, do you understand that this person, they're not working in a service station at 3 o'clock in the morning to make a huge amount of money. It's probably the only job they can get, and now they can't work in that job. How would you feel if that was your sister? How would you, those sorts of things. So it's a really important part of the proceedings, I think, for the reasons that the Chief Judge and Judge Gamble have already said, but it's really good for accused people because often they're so miserable and caught up in their own lives as well. They don't think about the effect that they have, and it often has a dramatic impact on the accused person. I have seen accused people, once you've spoken to them about, what do you think about this? How would you feel if this is your mum? How would you feel if this is your brother? And they'll cry. And it'll actually hit them for the first time that I've done this. I've done this to another human being. This is what my offending does. So I really like them from that point of view too.
Ed, can I just add one further example? An aggravated burglary on a home in the middle of the night to steal money from within the house or from the occupant. I mean, that's a very serious offence and would be traumatic for any victim householder, but consider it where it's an elderly person living alone. That can often be the catalyst for them having to leave an independent existence living at home with outside support, so then going into an aged care facility, and that can often be the start of the end of the latter part of their life when they should really be enjoying it. Instead, they are absolutely traumatised and their life changes forever.
Yep.
Thank you, judges, for those fantastic answers. We've had a flurry of questions from Ashwood High School, so definitely a shout out is warranted to all those students. I wanted to read a question now about the media, and I think all three of you would be no strangers to media coverage, having sat on a number of high-profile matters. So I'd really like all three of you to answer, if possible. The student's name is Hamza, and the question is it difficult to ignore the impact, the role of? I'll start again. Is it difficult to ignore the impact of the media when sentencing? What is the impact of the media, particularly when sentencing high-profile cases, and does it make the judge's role more difficult?
You're on mute, Chief.
There you go, students. That we've been in this for 6 months and I'm still getting the mute button wrong. All right, look, the media and sentencing. I think the first thing to be generally said is that most of the publicity comes at the time of sentence, not immediately before. Like, you do your plea hearing, especially with a high profile matter, you're going to have the plea hearing, and then you're likely to be sentencing on another day in a difficult or complex high profile matter. My point is that most of the media coverage comes at the time of your sentence and afterwards. But of course, some of it does come at the time of plea, of the plea as well, especially if it's high profile. The bottom line is that we are trained professionals. All of us were legal practitioners for many years, mostly barristers, either prosecuting or defending at the bar. And all of us, all three of us here, have been involved in cases as practitioners, which were high profile cases. And we're trained to focus on the law and on the issues and the evidence in the case. And of course, when we become judges, we take an oath to apply the law. And the law requires us to sentence according to the law and dispassionately. And that requires us to sentence on the evidence before us and without regard to emotional feelings that it might be happening out in the community. If we were sentencing in accordance with the emotions out there in the community, then that would not be a sentence according to law and would not comply with the rule of law. So the bottom line is we're able to, because of our experience, to focus on what's required in our job, apply the relevant legal principles to the facts and circumstances of the case, and dispense justice. And that's what we do. Can it be sometimes broadly difficult because there's a storm out there in the community? Well, we're also human beings. We're members of the community. We walk the streets of the community. We read what's happening. And look, sometimes that can be challenging, and we just need to doubly focus on our job, which is what we do.
The only, I agree with all of that. The only thing I would add to it is to say that apart from that challenge, it can also be an opportunity. High profile cases are more likely to be reported and reported extensively. So it can be an opportunity for the sentencing judge and through the sentencing judge to the court to communicate the sorts of considerations that the court has to take into account, and to some extent the difficulty of the task. And that is an important educative exercise. And for those students out there who want to follow a high profile case, or any case really, there's an opportunity to read the full sentencing remarks, either on the court's website or through online platforms such as Ostly or Jade. And it's important to read the full sentencing remarks, not just a media article where there are pressures and space requirements, so they can't necessarily provide a full and therefore fully balanced view of a case on occasion.
Sorry, I just want to add, sometimes I'll go out to give a sentence in a high profile case where I know I'm going to give a sentence that will be seen, unless it's reported in a way that, you know, often reporters just haven't got the time or space to do. Very much on a person's background, it'll be seen as incredibly lenient. And, you know, the one thing judges get really worried about is, you know, the person only got this or only got that. One of the things that we've brought in is a thing whereby we hand over the full sentencing remarks, and they're pages and pages long, and newspapers will now attach them as something you can click on to. at the end of the story. And we introduced that because we wanted people to be able to read the whole of the reasons why we do things, which often media just haven't got the time to do. It's often a bit hard for journalists as well because they get moved around a lot. And they haven't got law degrees. It's pretty hard for them to pick up a lot of the stuff that we do and why we do it. So look, they're all challenges that we have, but we work very closely with the media, particularly through Ed, who's the head of our, I suppose, well, he's the main media liaison person that we have, and that's a really important thing to do.
Can I just finish all that off? Like terrific comments by Mark and Liz. What I would ask you as students of the law to think about next time you see a 20-second grab on one of the commercial stations, which suggests that the sentence was too lenient, just think about this, that it's very likely that the judge who imposed that sentence has written 15 to 20 pages of carefully crafted reasons, which would take up to an hour to read. Yet the person who's watching that TV grab is getting a mere 20 seconds. Now, with the best will in the world, that 20-second grab is never going to accurately reflect what's occurred in that case. So I would encourage you, when you see that happen next time, go to our website and read the reasons and ask yourself whether that grab fairly encapsulated what the sentence was about.
Yep, really good call. I agree with that.
Thank you for assigning homework, Chief. Very good. I just want to put the next question out to the panel. We've actually had a couple of questions, most recently from Ashley in Frankston, a couple of questions about sentence indication requests or sentence indication hearings. For those who aren't aware, could you tell us what a sentence indication is and how do they fit into the sentencing regime?
Sure.
Well, sentence indication under the current legislation provides an opportunity to an accused person, if their application to get such an indication is accepted by the judge, to learn of whether or not the judge is likely to impose a custodial sentence or not. Now, in order for that to be an appropriate exercise, a judge would need to be able to be provided by both sides, both the defence and the prosecution, with all of the relevant information, including, for example, the effect or likely effect on a victim. Now, sometimes that's possible, sometimes it's not. If it's not, it may well be not an appropriate case in which to give an indication. But in cases where it is able to be done, an accused may, on learning that it's unlikely that they're going to be given a custodial sentence, be prepared to plead guilty to the offence. And that will have a number of benefits. The court won't have to conduct a trial with the cost and time that takes. The victim in the matter won't have to go through the ordeal of having to give evidence in a trial and be cross-examined. So there are definite benefits to the process, providing it's an appropriate case in which to conduct one.
Yeah. And the other thing to remember about that, in case students are thinking, well, why would someone plead, not guilty if they're prepared to plead guilty? The way trials run is that the prosecution has to prove the case beyond reasonable doubt. I'm an old defence barrister, so I used to work on the defence side. The first thing defence barristers do is you get all your statements and materials and you go through and without your client even telling you their side of things, you go, right, can the prosecution prove this beyond reasonable doubt? And sometimes there can be holes in a prosecution case that are very evident. And so your client comes in and you go, okay, they're going to have trouble proving this, they're going to have trouble proving this, they're going to have trouble proving this. So you can have a situation where, the whole thing about our legal system is the prosecution has to prove the case beyond reasonable doubt. And you could run a defence without cross-examining a witness, except for a few little things, or without getting your client, even getting instructions from your client, if the case wasn't strong enough. So because the system works that way, you've got a bit of room to move, which is why you have these sentence indications where somebody will go, well, you know, well, what'll happen if I do plead? And, you know, if it looks like it's not going to involve something too heavy, well, look, yeah, no, I'd rather get it over and done with. I'll do it that way. But it's not about making people plead guilty who aren't guilty, or people running sort of really horrible trials when they're guilty all along. The way our system runs, being where the prosecution's got to prove it, and if they can't, a person is not guilty. That means that you can actually move in to have these sorts of discussions. I hope that makes sense to everybody.
Thanks for that, Judge. We've had some really interesting questions about appeals, so I thought it might be a good one to put open to the panel as well. Particularly this great question from Louis from Ashwood High. He asks, what kind of emotions does a judge feel if their sentence is scrutinised and perhaps overturned or rejected by the Court of Appeal? And following that, does a judge learn from their mistake if a superior court changes the sentence?
Can I deal with that one? To quote the Chief Judge from an earlier answer, we are human, so no one likes to get overturned on appeal. But can I say this? It's an important safeguard in our system of criminal justice that if there is a mistake, then it is corrected on appeal. And can I also make the observation that sometimes that happens in the High Court, where the Court of Appeal have corrected a judge at first instance like us, but then on appeal to the High Court, the prosecution is successful in their appeal. So it just highlights the fact that sentencing is a very difficult and finely balanced exercise sometimes, and reasonable minds might differ on whether a particular sentence is within the range of available sentences or not. So the short answer to the question is, of course, we're human and we prefer not to be successfully appealed to the Court of Appeal, but we get over it. You know, we have a pretty thick skin. We realise it's part of an important part of the process. And yes, if we've got something wrong, we do have to learn from it so that we don't make the same mistake again.
Could I just quickly add to this? All of us don't, none of us like it. You know, you get a little note sort of saying that it's being appealed, and I think, but then it depends on what happens. When I've been a couple of times in a couple of trials I've run, I've looked at it and I've thought, oh my God, I totally mucked that up. Thank God the Court of Appeal's there. You know, a couple of times, you know, I've sort of thought, well, I deserve that. Other times with sentences, I'll get a sentence changed either higher or lower, and I thought, no, I still don't agree with that. But at the same time, and that doesn't mean you're not going to learn from it at the same time. You think, okay, well, you know, if I want my sentence to stick, is the way we call it, then I have to take that into account. But I can assure you, nobody likes it. And the Supreme Court doesn't like it when the High Court overturns them either. So, no, we don't like it much.
Can I just make a couple of observations about the appellate process? That there are very few disciplines which are designed to identify error and to have error corrected.
Really good point.
And our entire judicial system is designed in that way. Any decision we make, we publish the reasons. The reasons are then scrutinised by legal practitioners with a view to getting advice on whether they should appeal. And then if the appeal if an appeal is launched, the appellate court hears the case in open court for people to hear and see the argument, and then they publish their reasons, which are there again for people to scrutinise, including the court above them. So in some ways, being appealed, and indeed being appealed successfully, it's business as usual. We come to expect it and we support it because it's part of the system.
Yep.
And legal decisions are often complicated. often we're asked to make decisions which are novel, and so it's sometimes difficult to get it right first up. We may not have a lot of guidance. And as Judge Gamble said, that when it comes to sentencing, reasonable minds do differ. So even if you are appealed successfully, it doesn't mean that you've done a bad job. It just means the system's worked. Now, having said all that, sometimes appeals get a lot of attention. The reality is that only around 3% of our decisions from this court, for example, and I think it roughly applies to other courts, but from this court are actually successfully overturned on appeal. 97% of our decisions remain undisturbed. They're either not appealed in the first place, or they're appealed and they're appealed unsuccessfully. So we do very, very largely get it right, but when we don't get it right, we accept that's part of the system.
Yeah, you absolutely have to move on. I mean, if you sort of had a nervous breakdown every time you got appealed, you'd last being a judge about 10 minutes. So it's very much part of the process. And not one person, not one judge would ever agree with the proposition that we should do away with an appeal system. No. As the Chief just said, it's an incredibly important check. And as I said a couple of times, I've made absolute blunders that I wasn't aware of at the time. So, yep.
Thank you for those answers. I think we did have a lot of questions on appeal, so I'm sure they were appreciated. I've got another question from Louis, who's definitely going to win some sort of award for all these fantastic questions. He's asked, there's obviously a lot of new legislation and amendments being made. Do judges rush immediately to study and learn new precedents in case law or legislation? Or do judges generally wait until the relevant case comes before you to do that reading?
Liz, why don't you take this one?
Oh, thanks very much. That's because I've got no doubt that the Chief and Judge Gamble would immediately go and read the legislation and carefully read up on it. What generally happens is, and I think most judges do this, because we've got a terrific library staff, something will be sent around to say, look, you know, this is coming in, this is happening, here's what's being proposed, here's what's being passed, here's a significant case that's very much going to affect this aspect of the law that you have to deal with. So, of course, I will always read that. I couldn't say that I will always, you know, immediately say, I must stay back at work 2 hours tonight to carefully peruse this new aspect of the law. And indeed, it changes so much that often you can't. And it's the same when you're a barrister. You've got to keep up with all of this. Generally speaking, it's when it arises in a case that you have. But I can't think of a time ever where something has come up that is a significant change to the law, either by way of a decision from a superior court or by legislation, where I haven't known about it first. But I can tell you that when that case comes up, my knowledge of it will expand greatly.
Can I just add, and the students may be interested in this, Judge Gaynor's quite right. We've got very good support staff within the court who provide regular updates about important changes to legislation or case law. But there's also a resource which assists us and which can be accessed by members of the public, and that is the Judicial College of Victoria. Provides us with very important material in relation to changes in the law and just on topics generally. So if you're interested in a particular topic or something, that is well worth a look.
And as I've just got a general point to endorse everything that Judges Gaynor and Gamble have said. But I think the students, you might be interested to know that we place a great premium on judicial education today. Probably 20 or 30 years ago, it really didn't exist. Whereas today, collectively, we see that as very important. And it's largely judges teaching judges. So various judges take a particular interest in an area of the law. They might be particularly interested, for example, in the law of evidence, and even more specialised in relation to tenancy and coincidence evidence. And they may choose to provide a workshop or a presentation to other judges. So we're all learning from each other. Indeed, the Judicial College, which Judge Gamble mentioned, its primary purpose is as a source of education for all of the courts. And we rely upon the Judicial College to help run workshops, seminars and conferences. So like you, we continue to learn, and that's a very important part of our job, and that's one way in which we keep up to date with new developments.
Yep.
Great answers all. We are getting close to the end of questions, but we probably have time for one or two more. We've had a number of questions about dealing with the emotions of a case. One person asked whether you get frustrated by the behaviour of offenders. Another person asked whether you get emotionally tied up in the victim impact statements. I just want to put to each of you perhaps a question about how difficult is it to separate your emotions, particularly in the act of sentencing, and how important is it?
Who wants to go first?
Oh, I can go.
You're the chief. You go.
All right. Okay. Look, I think we've said it a couple of times today that whilst we recognise our responsibilities in dispensing justice, that we have to do so dispassionately, we're also human beings, and humanity, of course, informs our decision making. So that when we're involved in a terrible case, and all three of us here have been involved in terrible cases, it's emotionally challenging. I mean, criminal law, including trials and the law of sentencing, it's emotionally and intellectually taxing. And therefore, it can be mentally draining. And that's a challenge, especially when you're doing that week in, week out, year in, year out for many years. So you need to recognise that, but at the same time, we need to listen to the evidence, including the victim impact statements, and we need to approach the law with a view to what the law says and with a view to the evidence in the case. And ultimately, we have to dispense fair and reasonable justice, not emotional justice. So it's a difficult rope to walk. I don't think anybody would suggest otherwise, but that's what is required of us as judges in this difficult area of law.
Can I just add something briefly? Judges are, by dint of their training, both as barristers and judges, able to put those emotive feelings to one side ultimately. It's not to say they don't feel them throughout the course of a case. Sometimes in really difficult cases, it can be a roller coaster. For example, you can hear the prosecution, who will open a plea hearing first, describe the nature and gravity of the offending, including by reference directly from the victim impact statements. And that can be quite harrowing to listen to and to hear. The defence barrister will then stand up after that and make a plea on behalf of the offender. And as has been raised in previous questions, sometimes the upbringing of that offender can itself have been a horrific thing, which must be listened to and then taken into account to the extent that's appropriate. So it's a bit of a pendulum, you start to move back the other way. But the important thing, I think, in cases of that nature is to just take some time before, or rather from when the plea finishes until when you have to impose sentence, days or even weeks sometimes. And that allows for and facilitates that calm, rational analysis of the case and the relevant principles over time. If one had to impose a sentence straight after the prosecution opening or straight after the defence plea, they would be different sentences imposed, I suspect, and they may well be different again from what the sentence that is ultimately imposed after a calm period of reflection.
Yep. And judges talk to each other a lot about difficult sentences that they've got to coming up, because what you do is most of the time in a county court plea, because you've got to produce a long series of reasonings for why you are sentencing as you are. You have to summarise the offending, and you go through the person's history and all that sort of stuff. So you've got a fair period of time in which you can think about what sort of sentence you're going to impose, and the judge can choose how long they're going to take. And in that time, it's one of the things that starts at the bar, actually. All barristers go and discuss their their cases with other barristers. It's called the open door policy. And as judges, that continues. So if I've got a difficult sentence, I'll go and speak to 5 or 6 judges about it, more if I need to. That often helps sort of sort out, if I can put it in non-legal terms, where my head's at about that. So that's an enormously helpful thing that you do. And Judge Gamble's quite right about needing to take time when you've got a more serious sentence. The other thing that you get very used to when you've been sitting in court a lot, and when you've been a barrister yourself for a long time, as a defence barrister, I've had lots of clients who I just couldn't stand as personalities. That never interfered. You get very good. It never interfered with what I did in court. Never did. It was about how you ran it. And that sort of becomes a sort of cast iron structure inside you, that you're there to do a particular job, which is to apply the law properly. And so you get very used to almost emotionally feeling this sort of structure inside you that sits there while all these emotions wash all around. So that's very helpful as well, because of course, as you said, no human being is going to sit in a court and hear the things that we hear and not be moved or unmoved. And you know, you can go out of court and you just think, I'm going to have a few sleepless nights over this one. You tussle, you turn, you talk, you think, but you know that you've got this legal duty that you've got, and it sits there, and somehow you've got to pack this all in so it works and it fits with the job that, you know, each of us has sworn an oath to do. And that's where having experience is really helpful. But we have a large number of resources to go to, including each other. And so all of those things come into play when you've got a deeply emotional case. But the first thing you do learn after a while is when you've got a big emotional case, as Judge Gamble says, is to adjourn it off, go away and think and talk and those sorts of things. That's how I work my way through it, and I suspect most judges do. Thank you.
And Judge Gaynor said something there, which is so true, that effectively it's the law that's delivering this justice. It's not us personally. Yeah. And that's the way we look at it. We're guided. We're bound by the result, if you like, through the law. The bottom line is that there are a couple of cases. It may be that some of you out there have read these cases, but they talk about the process of sentencing as generally being an intellectual process, not an emotional process. And that really encapsulates what we're required to do.
Thanks for all those answers, judges. I hate to say it, but we've actually run out of time for questions, and I thank all of the students and teachers who've submitted such thoughtful questions today. The final section of today's panel is just to open the floor one last time to the 3 panelists to see if there was any closing words you'd like to offer this cohort of legal studies students before we wrap up for the day.
Liz, why don't you go first?
I haven't really got anything much to say to you guys except to wish you all the best. I've had kids go through VCE. I know how hard it is. It's a really anxious time, and particularly for all of you in lockdown this year. I'm sure you all do really well. The questions were fantastic. They were so intelligent, and they showed how much you've actually learned about what we do. They were far more sophisticated than I was expecting. I do a lot of we have a court program, and usually I expect when people come to court, and I'm talking, students come to court, they usually go, what's the worst, goriest case you've ever done? And that was as far removed from the questions today. It sounds to me like you're all going to do really well, especially Ashwood High. So good luck to you all, and I hope you all do really well, and good on you. What a tough time to be doing VCE. All the very best. I hope we've been some help to you.
I agree with that, Judge Gaynor, wholeheartedly. And can I just add a couple of things? One is to thank you for taking the time and having the interest in joining and participating in this webinar. We can't see you. We'd love to see you, but we can't, but we know you're out there and engaged and interested, and that's a great thing. The other thing is, whether or not you ultimately pursue a career in the law, please understand that studying law as you have in your VCE will stand you in good stead in life generally, whether it's in your career or otherwise. You may end up being summoned as a juror, who knows, but in the future. But can I just encourage all of you to take the time and continue to take the time from time to time in the future to come along and attend the court and to see how justice plays out in practice. It can be quite different to see it live like that compared to studying it from textbooks. What we're doing now is a bit of a hybrid, I suppose, and that's hopefully been of some benefit. But I would encourage you to just come along to court when you're able to. It's difficult at the moment under COVID. We're all, suffering with that. But I would encourage you to come along and witness justice, because it's important for the court and the community that we have as many people in the community who are informed about the court's work, as opposed to just being reliant on short snippets in the media.
Yep.
Chief Judge.
Thanks, Liz, and thanks, Mark. And I endorse both of what they've said. I suppose from my point of view, today is an important day because it's the start of this week this engagement week that we've got with VCE law students, not just in metropolitan Melbourne, but across the whole state. And for me, what's important about that is that we're using technology to allow you access to us and to information without you having to physically be here. Now, on one view, you might well think, well, that's what we've been doing for the last 6 months with COVID, and that's true. But we have been exploring this kind of option for some time now to better engage with school classes across the state. And even when we get out of COVID, we'll continue pursuing this as one of the ways in which we can engage with you. As Judge Gamble said, there's no better way than physically coming to a court, and whether you're in Melbourne or indeed in the country when we do circuits, there's nothing like actually physically coming into court. But on the question of technology, can I encourage you all to access the County Court's website? There's a large amount of educational material on that website. We've got I think we've mentioned we've got some important decisions which are published on the website, and even reading those decisions will give you a good insight into the way in which the law operates. But there's also some educational material on there which is specifically designed for VCE students. Of course, all members of the public can access it and learn from it, but it's actually designed to help you as VCE students. And you just need to follow the prompts. We've actually got a prompt there for educational resources, and over time we'll renew that. So we want to encourage you, as you're learning about the law, to remember that as both judges have said, the law is a real thing. It's a live beast. I'm often asked, is it a science or an arts? That's actually a trick question, because it's neither. It's mathematical at one level because it's incredibly logical, and it is logical. If the law is illogical, then people lose confidence in it. But it's logic mixed with some humanity, and human behaviour is often, as we know, incredibly complex. So we're a bit of a mixture of the arts and science, and that's what makes the law so fascinating. And I'm sure that for those of you who pursue it with your careers, you won't regret it. And like Judge Gaynor and Judge Gamble, I wish you all the very best, and thanks for joining with us today.
Yep. Thanks.
Thank you, Chief, and thank you, Judge Gamble and Judge Gaynor, for those really insightful and thoughtful questions. Just before we wrap up, I just want to let the students and teachers know about some of the resources available and what's coming up for the week. So if you'd like to head to our website, you'll see the full program for the week. We have, of particular interest to students, might be tomorrow's event, which talks about what it's like to be an associate to a judge, which is a role that you may pursue following your studies if you do go into the law. We also have a session on Wednesday about the specialist courts at the County Court. On Thursday, we have more careers advice and opportunities to ask judges questions about careers. And on Friday, the Chief Judge will host another Q&A where you can ask him on a range of topics, not just sentencing. So all of that information is on our website. And of course, you'll be busy with other things, so they'll all be recorded and they'll all be available to watch after the fact. And finally, Judge Gamble did mention that it would be a good idea to come into court and observe hearings. While that's obviously not possible at the moment, students are able to observe virtual hearings. So if any of the teachers or students would like to watch a county court hearing live, just get in touch with our communications team and we'll work out those details. So once again, thank you everyone for coming. That's the end of the event, and have a great afternoon.
Good luck.